click this out.
आप जिस व्यक्ति को कॉल कर रही है वह उत्तर नहीं, कुछ समय पश्चात प्रयास करिए।
May I please, Your Lordship?
Yes, yes.
Lordship, I beg to mention item number 32, hearing item number 32.
Yes.
On behalf of Senior Government Advocate Mao Imchen, Lordship. Lordship, if this matter can come up after 2 weeks, Lordship.
32.
Lordship, after 2 weeks.
Mr. V. Jamomi. It's a mention on behalf of Mr. Moemchin, and it's no government advocate, and 6 adjournment of the case for 2 weeks. Prayer is allowed, listed accordingly. Okay.
May I please, Lordship?
Yes, please.
I beg to mention item number 31 of the hearing list on behalf of Ms. Asana Waling.
Yes.
My Lord, here the leading concern was Ms. S. Longcomer, who passed away on 2nd of January this year. And then the brief are in her chamber. So I'm asked to mention for 2 weeks time to get the brief. So this matter may be listed after 2 weeks, my Lord.
Mr. N. Longcomer.
Yes, my Lord.
The Learned Council makes a mention on behalf of MS Asangla Waling, the Learned Council for the petitioner, and 6 adjournment of the case after
2 weeks, my Lord. My Lord, in the case, let it be 3 weeks, my Lord.
after 3 weeks. Prayer is allowed, listed accordingly. Okay.
May I please, Your Lordship? May I please to mention hearing item number 33. Your Lordship, the case of the petition is under consideration, Your Lordship. So another 2 weeks will be granted.
Okay.
Matter pertains to compassionate appointment. I have no objection for adjournment. However, Lordship, may kindly see the order dated 25/7/23.
What is that?
Lordship, time has been granted to government advocate to get instruction whether the case of the petitioner can be accommodated.
But they're saying
And
it's
the
under
vacancies.
consideration.
And thereafter, Lordship, on 5/6 question, same submission has been met that it is under consideration. However,
See, appointment is not always automatic. It goes through some various process. We have
there
to
are
give time to
vacancies
the
in fact,
government.
Lordship.
Mr. M.S. Livika, the Learned Government Advocate, submits that the case of the petitioner is under the consideration of the government, and therefore the matter may be listed after 3 weeks. Prayer is allowed, listed accordingly. Okay.
Lordship.
Much obliged.
From the supplementary course list for motion, item number 36.
Please, Your Lordship. This is application under 482. That's for passing of a complaint petition. And at the complaint petition, Your Lordship will find it page 33. So what happens, my Lord? This is the complaint petition was filed by the respondent number 1 against respondent number 2 and 3 under section 138 of the NI Act, my Lord. And the bank has been made a pro forma respondent to the party, which will Lordship will find it page 34. Is it Lordship? Got it? Here, the dispute is purely between respondent number 1, 2, and 3. The under the 130 of the NI. And the matter was listed on 11/12, which will Lordship will find at page 68. Say 68 is the order, my Lord. If I may read it, my Lord.
Yes, heard, Mr. Counsel. Counsel for the- This application has been filed under section 482 of the Code of Criminal Procedure 1973 for quashing of the complaint petition number CR case number for quashing of the complaint CR case number 21/2023
Any before the
pending,
JMFC debate.
please wait, pending before the learned judicial magistrate Dimapur, and also the impugn notice dated 13/12/2023 passed by the learned judicial magistrate Dimapur under section 138 of the Negotiable Instrument Act and section 420 of the Indian Penal Code in CR case number 21/2023. It is submitted by the learned counsel for the petitioner that the petitioner is the HDFC Bank Limited, Dimapur branch, represented by the branch manager and therefore no case under section 138 of the Negotiable Instrument Act and section 420 of the Indian Penal Code would have been instituted against the petitioner. Issue notice to the respondents to be heard in 4 weeks' time. The learned counsel for the petitioner shall take steps for service of notice upon the respondents by registered post with AD within a period of within a period of
3 days.
3 days from today. In the interim, the CR case number 21/2023 pending against the petitioner before the learned judicial magistrate Dimapur and the impugn notice dated 13/12/2023 passed by the learned chief judicial magistrate summoning the petitioner to appear in the connected case shall remain suspended till further orders. Okay.
For admission, item numbers 1 and 2.
May your lordship please.
Yes.
May your lordship please. So, hello, may your lordship please. This is an application under section 482 of the CRPC for pausing of the proceeding initiated by the Judicial Magistrate First Class Dimapur by the order dated 16/11/2022. Impugn order, I am reading the impugn order, page 70, annexure 5.
What is the stage?
Lordship,
What is the stage of the case? Admission.
that is that can be final heard because records are with before your lordship
Listed for hearing.
for hearing.
Yes.
For admission hearing, it is, I am giving the admission hearing, page 70 is a kindly lordship turn to page 70, impugn order.
Well, listed for hearing.
No,
The usual pause.
For hearing,
For
admission
hearing in
hearing.
the usual pause.
No, it is finally it can be disposed of today also, lordship. Records are before your lordship. Records have been called for because it is pending from 2022. Miscarriage of justice, it is purely a civil dispute. Purely a civil dispute. So I have supported the judgment also, Supreme Court judgment, 4 of judgment. I am
Listed for hearing in the usual course.
For admission, item numbers 3 to 13.
May it please my lordship, I received affidavit in opposition in writ petition 193, 194, 195 this morning, just now.
190, 193,
94, 95.
What about the rest? The others?
May I please, your lordship. My lord, I have instruction to appear on behalf of the private respondent in item number 10, WBC 196. So I may be given a short time to file my counter affidavit.
One 193, 194, 195 affidavit on behalf of
Lordship,
Lordship, for 193, Your Lordship, for 7 to 54, Your Lordship.
Okay, what about 94, 194?
Your Lordship, 94, 6 to 119,
Okay, what about 95?
8 to 94, Your Lordship.
The government has filed. Yes, the government has filed. What about all this 196, okay, 197, 198, 199?
May I please, Lordship?
Yes.
My Lord, item number 5, WBC 191. I'll be filing it during the course of the day for all the brevet respondents, 5 to 87. 191, WBC 191.
What
item-
about 189? 189,
I'm appearing for 189.
they filed your affidavit?
Yes, Lordship.
Yes. Okay.
189 and 190. Lordship.
Affidavit filed.
Yes, Lordship.
I am appealing, Your Lordship. I have filed affidavit.
To 191,
My Lord, I'll be filing during the course of the day. I'm waiting for the signature of the deponent, so we'll be filing it during the course of the day.
what about 192? 92, 192,
I'm appealing for analogous.
you are appearing for the state.
For the department.
For the department, what about the private respondents?
PSQ.
Lordship, I'm appearing on behalf of 192.
192, have you filed your affidavit?
Yes.
193 filed, 194 filed, 195 filed. 196, you are asking for time. On behalf of which respondents?
Respondent number 7 to 109. Private respondents, all the private respondents.
What about 197?
Lordship, I'm appearing in 197.
You have filed your affidavit?
Yes, Your Lordship,
Okay.
on behalf of all the private respondents.
Okay, what about 198?
198 also.
Okay. What about 199? Anybody appearing for 199? Mr. TB, you are for the department, 199.
Yes, for the official respondent.
Okay. What about the 199? Let us see 199.
One 199 here in my
Yes.
note, Lordship, none has filed here. Wakalat Nama on behalf of the private respondent, Lordship. Only the respondent government.
2, 3, 4, 5, and 6. Yes, 6 to 58 is therefore deemed served. You have published the notice,
Of course, Lordship, altogether.
therefore deemed served. Someone was mentioning 191, huh? 191.
Yes, my Lord.
You file your affidavit.
My Lord, I'll be filing it during the course of the day.
Correspondent number
5 to 87.
in WPC 191/2022. Mr. Takakicho submits that. He will be filing the affidavit in opposition. on behalf of respondent number 5287 in the course of the case. Sure. In regard to WPC 196/2022, Mr. So-and-so, Learned Council submits that he may be allowed 3 weeks' time to file affidavit in opposition on behalf of respondent number
626109.
6210. Here's any submission, ma'am? 193, 194, 195?
Lordship, they have filed this morning.
Yes.
I just received just now.
Will you be filing affidavit in the court?
Lordship may not, need not be.
With regard to WPC 193/2022, WPC 194/2022, and WPC 195/2022, it is submitted that the affidavit has been filed. Only today.
Yes, this morning I received.
Your Lordship, we have filed it yesterday, Your Lordship. We have received copy.
Filed
With cost they have filed.
recently, and the copies have been served to the Learned Council for the petitioner. They have given you cost.
No, Lordship, they were supposed to give to the bar. That I'm not.
Release the keys. After three.
Your Lordship, I have a small print.
Yes.
Lordship, as I said, I am a print in all the writ petition, Your Lordship, and I have filed my affidavit in opposition in all, Your Lordship. But Your Lordship, there are nearly 900 private respondents. At the time of filing my affidavit, Your Lordship, all the relevant records, documents pertaining to the training underwent by the private respondents were not available. So I have made a prayer in my affidavit also to allow the respondent to place the same on record by way of additional affidavit, Your Lordship. And those documents will be relevant. So if I may be allowed to file additional affidavit.
Mr. T.V. Jamil, the Learned Council for the department.
For the department.
Is also allowed to file additional affidavit, placing relevant documents on record.
Oblige, Your Lordship.
Listed after 3 weeks.
Oblige, Your Lordship.
Oblige, Lordship.
For admission, item number 14.
Please, Lordship.
Yeah.
Lordship, here I am for the state respondent, Lordship. Lordship, I'm here to receive instructions, so Lordship, may please to grant another 3 weeks time, Lordship.
Mr. B. Jimomi, the Learned Government is further granted 3 weeks time to file affidavit in opposition. Okay.
For admission, item number 15.
Please, Your Lordship. Your Lordship, I'm here to file counter, so kindly grant 3 weeks time, Your Lordship.
MS Inahuli, the Learned Government Advocate, is granted 3 weeks time to file affidavit in opposition.
For admission, item number 16.
Yes.
Your Lordship, here the state has already filed, Your Lordship.
What was the, this is item?
16.
When did you file? Madam, when did you file?
This matter is handled by my colleague AIME.
Okay.
I've been informed that she had filed, Your Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, here I am appearing on behalf of Apila Santam, Your Lordship, for respondent number 5, Your Lordship. Lordship, we're yet to file our affidavit, Your Lordship, if 3 weeks time be given.
Mr. M. Sullivan. Learned Counsel makes a mention on behalf of MS Apila Sankam. The Learned Counsel for the respondent number 5 and seeks adjournment of the case for 3 weeks to file affidavit in opposition. Listed report.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next returnable date.
For admission, item number 17.
May I please, Your Lordship? Lordship, here I'm for respondent number 2, 3, 4, 5, 6, and 7.
2, 3, 4,
5, 6, and 7. 2 to 7.
2 to 7. Mr. SNT, you are for?
I am for respondents 1, 8, and 9, Lordship.
1,
8, and 9. My presence may kindly be reflected, Lordship.
What is 1, 8, and 9? Is it the union?
Yes, union as well as NHIDC, Lordship.
Okay. And 2 to 7 is the state. 2 to 7 is the state. And ma'am, you are for respondent number 10.
10, yes,
Who is 10?
Chairman, Your Lordship,
Chairman of?
of the village council.
Full affidavits fine. What about Santi?
I have already filed, Lordship.
What about ma'am?
Lordship, I file.
My lord, I need to file my affidavit in reply to the affidavit being filed by the respondent.
What about chairman? What about chairman? What about the affidavit filed by the chairman?
I may be given 2 weeks time.
Will you file a reply?
Not yet, my lord.
No, will you file? Will you file?
If not, I'll file, my lord.
Mr. Raj Mohammed, the learned government advocate, submits that he may be allowed to file affidavit in opposition on behalf of respondent number 2 to 7. By granting 3 weeks time. Mr. Pankin Richabu. Mr. Pankin Richabu, the learned counsel for the petitioner, also has similar prayer to file affidavit in reply to the affidavit in opposition filed by the respondent number 1, 8, 9, and 10. Prayer is allowed, listed after 3 weeks. The name of
Lordship, my presence may kindly be
the name of Mr. Sintianga, the learned counsel for the respondent number 1, 8, and 9 shall be reflected in the daily course list. Mr. Santi, your name is.
This order, Lordship. In the order
Okay.
that I appeared, Lordship. Because it becomes difficult for billing, Lordship.
Mr. Santianger appears for the respondent number 1, 8, and 9.
My lord.
Yes.
Highly obliged.
For admission, item number 18.
Yeah, please, Your Lordship.
Yes.
Lordship, can you grant 2 weeks time to file the counter, Lordship?
MS S. Chang, the learned government advocate, is granted 3 weeks time to file affidavit.
Much obliged, Lordship.
For admission, item number 19.
Please, Lordship, I'm making a prayer on behalf of AIME Here, your lordship, she is yet to file counter, so kindly grant 3 weeks time, your lordship.
MS Inaholvi makes a mention on behalf of MS AIME, the Lieutenant Government Advocate, and seeks adjournment of the case for 3 weeks for filing affidavit in opposition. That is allowed. Listed at the-
Much obliged.
For admission, item number 20.
So, your lordship, here, I'm also yet to file counter, your lordship, so kindly grant 3 weeks time, your lordship.
Is MS Inaholvi, the Lieutenant Government, seeks for 3 weeks time. to file counter affidavit. Where is allowed? Listed at the- Okay.
Much obliged.
For admission, item number 21.
May I please, my lord?
Yes, please.
Lordship, making a mention on behalf of my colleague S. Murray. Lordship, I'm told that she is yet to receive instruction to file her counter affidavit. So if 3 weeks' time can kindly be granted, my lord.
MS S. Mary, the Lieutenant Senior Additional Government Advocate, is granted 3 weeks' time to file affidavit in opposition.
For admission, item number 22.
Lordship, in this matter also, I have a similar prayer, my lord.
Similar to, okay.
I'm deeply obliged, my lord.
For admission, item number 23.
My lordship, I'm on behalf of state respondent number 1 and 2. Lordship, I have yet to receive an instruction. So I request to grant 3 weeks of time.
The Government Advocate is granted 3 weeks' time to file affidavit in opposition. Okay. Any interim?
No, your lordship.
For admission, item numbers 24 and 25.
What is this? This is listed for the first time? No. Yes. Yes, what is this? Anticipatory date? Is directed to transfer the. This order was passed from the principal set.
Yes, Lordship.
Mr. Vijimami, are you appearing in this case?
Lordship.
You get the case dial?
Lordship.
Heard Mr. So and so. And your?
And for the one in criminal petition,
Okay.
which have 2 weeks time will be given to file our affidavit.
Third, Mr. So-and-so. Learned counsel for the applicant. This application, stop, this application has been transferred from the principal seat. Stop. Mr. Bijmomi, the learned public prosecutor, shall produce the scanned copy of the case diary. When?
After a week.
On, let us give a date.
Twenty-nine, Lordship.
Criminal petition is connected. Connected
Lodged.
on 8/2/2024. Stop. The interim order passed by this court on 22/12/2023 shall continue till the next date on the same terms and conditions. Listed accordingly. Then in criminal petition 18, MS Lucino. I'm sorry, MS Rikatsono, the learned counsel for the petitioner. Six respondent for the respondent number 1. 6 for some time to file affidavit in opposition. Listed on 8/2 on the same day. Listed on 8/2/2020.
Obliged, Madam.
For orders, item number 26.
Yes, what is this?
So this is regarding a contempt petition, violation of your lordship's order itself. Regarding that compensation issue, if your lordship will come to the page 21, direction was there for releasing of that particular compensation amount within 6 months from passing of the order.
This is a judgment passed by DB.
Yes, by the DB. Contempt petition lies before a single judge, lordship, as per High Court rules.
Show me the rules.
I am not carrying the rules, but I have checked up when it was filed.
Show me the rules. Let me first see the rules.
Yes. The High Court rules.
Yes, government.
The development presently is that the money is
Yes.
also sanctioned,
Government,
but they are not releasing.
My
The
lord,
state is not releasing.
why you are not releasing the money?
By order dated 7/12/2023, Your Lordships, we have already communicated to the ministry concerned by 3 letters.
We have not received the money from
No,
the
no, money
So
is
far,
there.
we have received money, but since the agency, the recovery of the total
May I
amount will
just-
be
may I
recovered
just
from
submit one?
the
Just
agency
wait.
No, I can
charges.
clarify this.
Just wait. Yes.
Whereas state is only a supervisory agent, we cannot pay the compensation from the state exchequer. That is how we have written to the ministry as per the Honorable Court's judgment on order dated 30th January
And have you
2023.
received the fund from the central government?
Yes, Your
Yes.
Lords, we are ready to comply with.
Then-
We are ready to pay. However, the entire money has to be recovered from the state agency charges, which is not in the guideline. We, as state respondent, we are
Okay,
only
I'm
authorized
a
to
little
do
confused.
the,
You are, actually the central government has sanctioned the money
yes, Your Lordship.
to you.
Yes,
You are supposed to disperse.
yes,
Yes.
my-
And the central government is supposed to recover that money from the state.
yes, Your Lordship. That is the problem with us. So we have accordingly, as per the order dated 7th December 2023, we have written to the ministry. We have 3 letters written to the ministry concerned to reconsider the recovery from the state agency charges.
What was the
May I-
direction? What was the direction in the judgment order?
Page 21, if your lordship will see.
What is
The
that?
money was supposed to be sanctioned by the
By-
state, by the center, disbursed to the state, and the state thereafter will give it to the DC, and the DC will accordingly, after verification, give it to all the landowners. That was the order. Page 21, last paragraph, to be more specific, lordship. And if your lordship is looking at the rules, it is Appendix 7. Rule 5, Subrule 1.
When can you release the money? Mr. Additional Agent? If there is any issue between you and the central government, that is your issue. The central government has sanctioned the money.
Yes,
The
my
money
lord.
is with you.
Yes, my
Pay
lord.
it. Pay it.
My lord, if I may be allowed to refer, page
No, there's no question of
57
reference.
of the contempt petition at the last paragraph, my lord.
Uh,
May I read, my lord?
what is it?
No mention is made about the recovery from the state agency charges, which the
See,
ministry has sanctioned.
it's all right, it's all right. The ministry has sanctioned. Now any issue for recovery is between you and the ministry.
However, my lord, we as a state
No,
respondents, we are only acting as agency.
so pay. As the agency, pay the money which is sanctioned by the central government. Pay them. And then afterwards, if you have any issue, you sort out with the central government.
We have
Okay,
written
okay.
3 letters, your
It's all right, I'm
lordships.
not bothered about that.
We are awaiting the,
No, waiting. Hey. The central government has sanctioned the money, you pay. You
but
pay.
no mention is made in the judgment and order
So what?
about the recovery of the money being
That's why,
sanctioned
the,
from the state
the
agency
issue is
charges.
between you and the central government. Whether mention is made or not, that
But
issue
so
is,
far, respondent number 1 has never appeared before this honorable
who is
court.
respondent one?
The ministry, donor
Minis-
ministry,
The,
secretary to the ministry.
They have already
they have
sanctioned the money.
sanctioned the money.
And the
What
money
is
is
the
in the DC
contempt?
effect now.
The contempt if any lies with you.
Yes, lordship.
We are only respondent number 2 in this.
I'm not bothered
contempt.
about that. You have received the money, pay.
And we are not in a position to recover from the agency charges
is a different
because
aspect.
agency charges is made only for certain certain exercises.
You have a talk with the government. I'll give you some time. You next time you come with instructions when you can pay. When
Yes,
you
my
can
lord.
pay. No other excuses. When you can release, give a specific date. Give a specific date. If not, we will issue notice for contempt.
If that be the case, my lord, may be pleased to allow 3 weeks' time.
No letter setter between you and the union. We are not going to take that into consideration. Any issue you sort out with the ministry. But here we want you to pay the money since central government has already released the money. So we want an assurance from you when you can pay the money. The money is in your hand. The money is in your custody. What
Yes,
is
my
the
lord.
difficulty?
Yes, my lord. However, no.
You are saying that there is an issue between the central government and the state government. That issue is between you.
State
Where is
government
the-
is not in position to recover the money.
You actually sort out. The money has been paid. How can you stop? How can you stop from disbursement?
Ultimately, the state government will face the.
We are not bothered about. We are not bothered about that. You have received the money from the central government. Pay, sort out.
Which later on will be.
We are not bothered about that. We are not bothered. We are not concerned about that. You have received the money from the central government. Pay. That's all.
On 27th October itself, it was sanctioned. 27th
Yes.
October.
So when can you pay? We will give you time.
My lord may
And
be
we will
pleased to, my lord may be pleased to grant us time so that we can receive a very specific reply from the
No,
ministry.
I'm not bothered about reply. This court is only concerned about when you can pay. When you can pay. This is a contempt.
Yes.
When you can pay, we are not
My
bothered
lord-
about the correspondence.
We will write a last letter to
No,
the
no, no,
ministry.
no, 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 no. We are not bothered about that. We are not bothered about that. You write or you don't write. That is not the issue in the contempt.
If in that
We will
case-
record. We will record.
Yes, my lord.
We will record that, like we are giving you time on condition that we will record the submission on or before the next date fixed. The money will be dispersed.
All the exercises, my lord may be pleased to grant us 3 weeks' time so that we will be in a position. to
What
come with-
exercise?
On last occasion, on
These are all
7
subsequent
December
issues between the state and
2023,
center.
this honorable court has passed a specific order. If I may be allowed to read, my lord,
Last paragraph.
last para. That is, if I may be allowed to read, my lord. Taking into account that certain clarifications are required within the Ministry of Road Transport and Housing, it should be National Highway, Your Worship. Government of India, as well as the Government of Nagaland, Works and Housing Department. This court directs the state departments of the Government of India, as well as the Government of Nagaland, to resolve the issue on or before the next date and place the same by way of an affidavit to be filed.
So on or before the next date means you have
The
failed to
petitioner
comply.
is given likely to serve copies of this order to the respondent number 1 and 2. Whereas this
Mr.
later,
LT Sangtam,
yes, my lord.
don't read something which is against you.
This sanction has already been exhausted by them now.
You were given the last chance
Yes.
to be complied with on or before the next returnable deed.
Yes, my lord. And I've received these letters only this morning.
So they're not supposed to get any
So
more
I
time.
may be
also,
allowed
in my humble
to
submission. The chance is already over
come up
exhausted
with
by
a
them.
compliance within 3 weeks' time
With compliance.
with
With compliance, yes.
instruction, your worship, instructions. my
This
lord.
is clearly contempt of this honorable court, Lord. So deliberately they are stopping this money.
What
violating the
instruction?
court's
You will
order.
come with the same excuse.
My lord, within 3 weeks' time, I may be allowed to come up with all the figures.
More than 6 months, the order has been violated now, Your Lordship. I leave it to Your Lordship, but this is clearly a deliberate.
As a
contempt of
last
honor.
chance, your worship.
Because what they are talking is something that will be subsequently decided between the state and the center, not something to deal with this honorable court's judgment and the aggrieved public at large. This recovery aspect is a thing that can be decided between them on a later stage, but nothing to do with the present issue that is before Your Lordships. The money is there with the DC.
When has the money been sanctioned? Is there any document?
20, yes, additional affidavit, Lordship. Additional affidavit filed on 24th November. Lordship will see at page 11. Page 4, sorry.
Additional affidavit.
Additional
this
affidavit?
is Contempt. In the contempt.
Yes, Lordship, in the contempt.
Additional affidavit.
Yes, page 4, Annexure 1, 27th of October 2023. The money has been sanctioned. And my current instruction is that the checks have also been deposited in the official account of the DC FEC. And he is only waiting for the final approval of the state government for release, as per Honorable Court's direction.
Add Mr. So-and-so. Learned counsel for the petitioner. And Mr. L. T. Sankam. Learned additional advocate general.
Assisted by Wisdom.
You are not supposed to be assisted. You are not supposed, are you a designated?
Yes, Lord.
Are you a designated senior?
No.
You are not supposed to be assisted. Add L.T. Sankam, then a senior additional, along with Mr. V. Jimobi, then a common. Then government advocate for the contemner respondents. In the light of in the light of the judgment and order dated 31/20/23, passed in PIL 9/2019, the Government of India, Minister of Road Transport and Highways, within bracket, NER zone, as on 27/10/2023. Sanctioned a sum of rupees 60 crores 94 lakhs 36,685 only. To the state government for disbursement to the affected lane owners during the construction of what?
Two-lane road, Lordship.
During the construction of two-lane road between
Fact Fujero Road
Fact Fujero Road
under SARDP NE
under SCRDP
NE within bracket Phase A project.
Phase A project. Stop. Despite the central government sanctioning the amount of rupees 60, 94, 36, 685. For disbursement to the affected landowners, the amount is yet to be disbursed. Mr. L.T. Sankam submits that the amount could not be dispersed to the affected landowners in view of the condition contained in the letter dated 23/11/2023, which provides that within inverted, subject to the condition that the amount shall subsequently be recovered from agency charges of state PWD of Nagaland. Mr. L.T. Sankam submits that the matter has been taken up with the central government. However, the matter is yet to be resolved. the issue as to whether the amount sanctioned by the central government is to be recovered from the state is an issue to be resolved between the state and the center. So, but the state respondents, but the container respondents cannot stop the disbursement to the affected landowners on the ground that there are issues to be resolved between the Ministry of Road Transport and Highways and the State PWD Department, State PWD of Nagaland. Mr. Devti Sanktam submits that a last chance may be granted to the state to resolve the issue with the central government and to disperse, and thereafter to disperse the amount to the affected landowners. This court accordingly grants one more last chance to the state government, to the respondent containers, to resolve the issue and to make the disbursement to the affected landowners. It is made clear that no further chance, no further opportunity shall be given to the state to make the payment to the affected landowners. Listed on. You take your time.
At least 2 months' time may be granted.
Money is already there with them.
Listed on.
22nd March.
The money is already with them. Such a long period of time, I do not understand why.
Listed on 29/2/2024.
Yes, Your Lordship. Oblige, Your Lordship.
Excuse me for 2 minutes.
For orders, item number 27.
Yes.
Lordship, here, all the respondents, they have appealed, Your Lordship.
May I please, Lordship? Lordship, I have an instruction to appear for respondent number 3, private respondent number 3. Lordship. So kindly grant me 3 weeks time to find my power as well as
How many
my
respondents?
affidavit in
Three, Your
opposition.
Lordship.
Yes. MS Pichano. Government Advocate. As well as your good name,
Lordship, Mr. Kajishi, Lordship.
Mr. So-and-so. Then counsel for the respondent number 3 are allowed 3 weeks time to file their respective listed report.
Much obliged.
For orders, item number 28.
This is I think, there's a review, no?
Lordship, civil review 5 of 2023, that is fixed to be listed after a week on the ground of MTM song. So this matter may be taken together along with the review application, Lordship, and be listed after a week.
What is that review number? Review,
Review is civil review 5 of 2023.
civil review 5 of 2023, correct? Let the civil petition be listed, be tagged with civil review 5/2023. And list on, we have, I think we have fixed the date, huh?
No date was fixed up to be listed after a week,
And listed after a week. Okay.
along with civil review.
Yes.
For hearing, item number 29.
My pleasure, Lordship.
Yeah.
Lordship, I beg the motion on behalf of Inhauli. Lordship, I kindly list this, but after 2 weeks.
The Leonard Government Advocate 6 adjournment of the case. Where is allowed listed accordingly. Okay.
For hearing, item number 30.
Please, Your Lordship. My Lord, pleadings are complete in this matter, Lordship. May be listed after 2 weeks for admission hearing.
Yes, please.
My Lord, pleadings are complete in this matter.
Ah.
So may be listed after 2 weeks for admission hearing.
No, this is for hearing. Where is the question of admission hearing?
Lordship,
On the prayer of Mr.
yes, it's for hearing. KR Khan.
KR times. Prayer of Mr.
My lord, the pleadings are complete in this matter. So, may be listed after 2 weeks for admission hearing.
No, this is for hearing. Where is the question of admission hearing? Yes, Mr. Louis, come, switch off your.
Yes.
There's disturbance from your end.
On the prayer of Mr. Yes.
KR.
Yes, my Lord.
Learned counsel for the petitioner. adjournment of the case after 2 weeks. Here is all listed above.
Obliged, my lord. For hearing item numbers 34 and 35.
Mr. Tipi, what is this case about?
This is with regard to the appointment to the post of CG and the OT, Operation Theater Technicians, who were appointed on the basis of an advertisement. And the recruitment was done during the COVID pandemic on the basis of a policy decision of the government. So the posts were created during the COVID pandemic and advertisement was issued. An open advertisement was issued showing that the posts are on regular basis. Now, after the selection process was commenced, when the appointment order was issued, it was appointed on temporary basis and that too on contract for a period of 1 year only. And the posts are to be recruited through the NPSC and the NSSP. So we are agreed by that. The Indian order is dated 2/11/2022.
You are agreed by the advertisement?
No.
Then?
I'm agreed by a notification I'm agreed by sending the requisition by the government. The post held by us to be recruited through NSSP or the NPC. Whereas the initial recruitment was done on the basis of an advertisement.
For a period of?
Regular appointment. It is very clearly shown. And some of us who were working on regular basis in other states had to resign and we wanted to serve in the state and appeared to interview and then they were selected also. Now, after the recruitment process is over, then they have changed the terms and conditions of the advertisement. That is a whole issue, Lordship. And
as per the advertisement, you appeared for the interview. And there was in the advertisement, there was no condition that it is for a specific period of 1 year.
Correct,
There was no
Lordship.
condition.
Lordship.
You were appointed regularly.
Yes.
Thereafter, another notification came out.
Yes.
Stating that actually this post has to be requisitioned to the NPSC. And
Yes.
Yes, Mr. Jim, just let me understand the gist.
Yes, Lordship. No, Lordship.
Why?
My learned friend is misconceived, Lordship. As far as the point, the post creation itself, Lordship. The cabinet took a decision to create posts, various posts, Lordship, under medical department during COVID time. Now, under clause B of the memorandum.
Clause B.
Okay. Annexure A, Lordship. There it says that department should clearly indicate that this appointment will be temporary and regular recruitment should be conducted through special NPC recruiting drive. This is a cabinet decision, Lordship. They have annexed in the writ petition. They have been inadvertent on a part of the department while issuing the advertisement, but that has been corrected by way of a corrigendum that this appointment will be on temporary basis.
That is before the exam.
Yes, before exam. They appeared, Lordship. They accepted the appointment order, which is in temporary basis. They have worked, Lordship. They are fully aware of the terms and conditions of the appointment order. And Lordship, when the cabinet created the post, it was decided that this appointment will be on temporary basis. Department shall carry out the recruitment. It was during the COVID time, Lordship. There was a need for HR, human resource, Lordship. There was shortage of manpower. So to cope up with the requirement of the COVID pandemic, Lordship, the department has conducted the recruitment, which is on temporary basis, Lordship. And the cabinet has made it very clear, regular recruitment to be done through special recruitment drive.
And this post, which is under challenge, this OT technician and ECG technician, they fall under the parameter of NSSP. So they have to go through the regular recruitment process, Lordship.
When the cabinet has taken the decision, the NSSP has not been constituted yet.
But now
Therefore,
it's now
the
constituted.
cabinet decision is not applicable so far as the ECG and OTs are concerned, Lordship. Lordship can hear the matter. I can systematically apprise to your Lordship. It is a short matter.
No, Lordship, the only question is whether without going through the regular selection process, whether the petitioner can come before this court, reinterpret the cabinet decision, Lordship.
Initial advertisement was done on the basis of the cabinet decision.
Yes, and the cabinet decision says it will be a temporary basis.
No, we are not, that is not,
Lordship, it's
clause
annexed
B
in the
is not
petition.
applicable to us.
No, it's applicable to all of them, Lordship.
No.
Thereafter, Lordship.
That is why, Lordship.
The cabinet has taken a decision to conduct a special recruitment drive by giving them due weightage of the COVID duty, Lordship. I have annexed in my reply, Lordship, affidavit of opposition. Due weightage will be given to them, Lordship. Lordship, in fact, there are a series of cases. Dental doctors are there, Lordship. Ayush doctors are there. Staff nurses are there. They are all seeking for regularization. And the one of the case filed by Mrs. Zed's Momi, which the Lordship cannot take up the matter because that was pertaining to the ATNA. Even for them also, they were appointed on temporary basis. They are asking for regularization of the service. Similar matter, Lordship. Now, the interpretation of the cabinet decision, Lordship. This has been clarified by issuance of the cabinet memorandum dated 12th of May 2022, whereby the cabinet has taken a decision that due weightage should be given to those recruitment to be done by the NPSC as well as the NSSP. So, Lordship, the crux of the matter is this, Lordship. Yes, initially when the advertisement was issued by the department, they inadvertently issued the advertisement on regular basis. That was issued, that was corrected by way of a correction of Lordship. Because
Before
exam, before exam,
the candidates appeared their exam.
before the candidate appeared exam. Lordship, this post has to be recruited through recruitment process, Lordship. Unless those candidate, the candidate goes through a regular recruitment process, Lordship. Because during the COVID, Lordship, because of the situation, unwanted situation, all the interviews were conducted through Zoom, online, taking consideration of the academic marks, Lordship, and the interview.
Mr. Wickham is a part of this case.
Lordship.
Yes, Mr. Wickham, anything?
Lordship, I think he's waiting for item number 29. That has already been mentioned.
I think
Ma-
we should exit.
Yes.
My lord, there I would like to pray for extension of the interim order, my lord.
Which item?
Item 29, my lord.
Okay.
Yeah.
Item 29.
Yes, my lord.
Interim order granted earlier shall continue till the next return. Okay.
Most gracious. Most.
Because Lordship, all this recruitment were done during the COVID time, and Lordship has taken up the issue of the staff nurse case, where the Honorable Court has upheld the cabinet decision with regard to giving Q system 50.
No, that is different, Lordship.
That is different, Lordship. But all this recruitment come under this category, Lordship.
Okay, let us hear you. Let's.
Yes.
Lordship.
Lordship, may kindly come to Annexure A, page 18 of the writ petition.
Yes.
I'm
Yes, wait.
holding 292 of 2022 as per the.
292.
Yes.
Yes.
They are belonging to technicians, in
290.
short, ECG.
Which
Through
page? Which page?
Page 18, annexure A. Because unless we analyze the background, how the cabinet has created the post, under what situation, that will be necessary, Lordship. It is a cabinet meeting held on 23rd June 2020, that is during the peak of COVID-19. Has your Lordship got it?
Yes, yes,
Uh,
just wait, just.
Let me refer only to the relevant
Just
portions.
wait, memorandum.
Minutes of the cabinet meeting held on 23rd June 2022.
Yes.
In most of the correspondences, it is shown as 25th June 2020 because it was communicated on that day. Otherwise,
This is 25th June 2020.
2020, yes. But the meeting was held on 23rd June 2020. This is a policy decision of the government. Let me start from the second paragraph. The Health and Family Welfare Department submitted a comprehensive proposal for creation of post. The department presented the manpower status indicating existing regular and contractual manpower as compared to the norms of the Indian Public Health Standard. The cabinet deliberated the matter at length in the backdrop of unprecedented situation arising out of the COVID-19 pandemic and the need to address the inadequacies of the state health system, including shortage of manpower at requisite levels. After detailed deliberation, the cabinet approved creation of the following post in the Department of Health and Family Welfare. This is the decision where the decision was taken to create the post. We are concerned with serial number 8 and 9, that is in the bottom of the page. Creation of 10 posts of ECG technician for district hospitals. Number 9, creation of 13 posts of OT technicians for district hospitals. So this is the post creation decision for post creation. And then kindly come to the next page, which is very important, especially A and P. We are concerned with only A and P. My learned friend was trying to highlight about the clause P, but I will highlight clause A, Lordship. What is the relevance?
This is to do with which post? You have two writ petitions.
Yes, this is to do with ECG. Serial number 8, 10 post of ECG technicians. And the other case is OT technicians, serial number 9.
Yes.
Now, A and B will be relevant for us. Let me, page 19. Let me read A first. The cabinet further directed that A, all the newly created posts should be filled up by the Health and Family Welfare Department within a month's time with proper advertisement. With proper advertisement, Lordship may take note of this. While filling up the post, 2 weekdays should be given to the marks obtained by the candidate in the qualifying degree of the university, medical college, and years of work experience. The interview panel should include independent experts from outside the state. Now, here, Lordship will find, Cabinet has said that with proper advertisement and the Health and Family Welfare Department was directed to fill up the post. And this was decided in view of the fact that, in view of the backdrop of unprecedented situation arising out of COVID-19 pandemic, Lordship. Cabinet has clearly stated that with proper advertisement. And pursuant to this decision, advertisement was issued. But before I go to the advertisement, another point will be very relevant, that is clause P, which my learned friend has tried to highlight before your lordship. I'm switching over to P. The department could clearly indicate these appointments will be temporary and regular recruitment shall be conducted through special NPSC recruitment drive. Here, there is no NSSP. It only mentioned about NPSC recruitment drive, special recruitment drive. The post of ECG and OT technicians do not come within the purview of the NPSC. But my learned friend is trying to show that, look, Cabinet has already taken a decision that the post will be temporary and regular recruitment shall be conducted through a special NPSC recruitment drive. That is relevant only for the other posts which are shown, because there are junior specialized doctors and then Ayush doctors, which posts are coming within the purview of NPSC. And why I'm making this submission is the NSSP was notified in the Gazette only on 31st July 2020. Therefore, while taking the decision by the Cabinet at clause P, the NSSP was not constituted at all. Therefore, this is not applicable so far as the petitioners are concerned in both the cases, because they are not coming.
NSSP notified in the Gazette only on
31st July 2020. That is after about 7 days. Therefore, this decision P of the Cabinet is not applicable so far as ECG and OTs are concerned. It talks about the posts which are coming within the review of the NPSC. I'm not saying that they have not taken a decision. They have taken a decision, but this decision clause P is not applicable to us because it talks about the posts which are coming within the purview of NPSC. And it is clearly mentioned even in the decision of the Cabinet also. Therefore, the submission which my learned friend has advanced is not applicable so far as ECG and OTs are concerned, so far as the petitioners are concerned. Pursuant to his lordship, the posts were created. And the background is that the Cabinet has created a post in the backdrop of the unprecedented situation arising out of COVID-19 pandemic. And the Cabinet has clearly said that the Department of Health and Family Welfare should fill up the post with proper advertisement. And then the posts have been created. Post creation order is at page 20. Type copy lordship will find at page 21, which is more clear. Page 21 is the post creation order, and the posts pertaining to the petitioners are shown at serial number 8, where the 10 posts of ECG technicians were created for the hospitals at pay level 5, which is not coming within the purview of the NPSC.
8 and 9.
Page 21.
8 and 9, serial 8 and 9.
Serial 8, yes, serial 89. And in the last line of the order, serial number 4, lordship will find this has the approval of the Cabinet-wide decision dated 25/6/2020, as I was referring, although the decision was taken on 23rd June 2020, but in most of the correspondences, they have referred this decision of 23rd June 2020 as 25/6/2020, since on this date it was communicated. So the date of communication was treated as the order. And next page, your lordship will find in the advertisement, how the advertisement was issued, page 22, Annexure C. Has your lordship got it? This is advertisement dated 16 July 2020. May I read, lordship? In pursuant to notification number so and so dated 2nd July 2020, that is the post creation order, applications are invited for recruitment against newly created posts on regular basis. This is very important, lordship. On regular basis, under the Department of Health and Family Welfare, through the department recruitment port, in the manner prescribed below. And then the name of post, serial number 1, that is ECG technician, and the number of posts, then others may not be that relevant.
This is through the department recruitment board.
Yes, because cabinet has taken a decision to relax the recruitment rules in view of the COVID-19 pandemic, lordship, by a policy decision. Lordship will find in the last, towards the end,
This is for 10 posts of technicians.
yes, ECG technicians. So advertisement is very clear that it was on a regular basis. And kindly come to next page, the terms and conditions for ECG technicians. I am referring to clause, paragraph 1, clause A on the top. Eligibility criteria. Those who have resigned from contractual service without any valid reasons during the COVID-19 pandemic crisis shall not be eligible to apply for a recruitment drive. See how stringent conditions are imposed. If anybody who are on contract or casual, work charge, whatever, if they resign, maybe fear of life, all this, they will not be eligible to apply for the post. This shows that they are very, very serious that they want manpower. They want to recruit. And not only this, when they come to next page, clause C, they were directed to sign a bond also even. Shall sign a bond not to engage in private practice. Because when a person is appointed on a regular basis, definitely they are not part to go for private practice. And then the next page, page 25, is the advertisement, copy of the advertisement, which was published in the newspaper. It was widely published, and the type copy lordship will find at page 26, but I have already referred to this document. So I need not spend time on this, lordship. Now, when the appointment was issued on 29 August 2020, page 27, Government is saying that, look, by filing a affidavit, government has said that, look, with open eyes, you have accepted the terms and you are aware about the terms and conditions of advertisement. You have accepted, so now you have no right. That is what they are saying, because when appointment was issued, it was issued on temporary appointment, as temporary appointment. Page 27, has your lordship got it? Administrative approval of the department recruitment board recommendation for temporary appointment of OT technicians and ECG technicians.
OT technician. This OT technician and ECG.
Yes, this
These are the
petition is,
petitioners.
this petition is pertaining to ECG technicians.
This is ECG.
Yes. There are 10 posts. The administrative approval has been given for temporary appointment. Therefore, we have objected by submitting representation also. And when we approached the authorities,
Just read this administrative approval.
Yes.
Just can you read it?
in inviting a reference to your letter number so and so, that is 17/8/2020, I am directed to convey herewith administrative approval of this departmental recruitment board recommendation for temporary appointment of candidates to the post of 12 OT technicians and 10 ECG technicians, grade 3, against the directorate and district under DHFW. The approved recommended candidates as per the merit list are mentioned below. The terms and conditions of recruitment appointment will be governed by this department's notification dated so and so, 5 July 2020.
Where is this 5 July 2020?
Last page, next page, Lordship. And type copy, Lordship will find at page 29.
Okay.
Let us refer to the type copy.
Okay, let us continue with page 27. Continue with page 27.
27, yes. ECGs in the bottom paragraph, Lordship.
Yes.
So there are 10 posts. These are the petitioners. Against this, we have objected.
Why objected?
Because the advertisement was for regular appointment. So we said for the regular appointment, we applied because advertisement says it is for regular appointment. So we applied in response to the advertisement. But when administrative approval was given, it was mentioned for temporary appointment.
Temporary appointment itself is a regular appointment.
If they say that, well and good, Lord. But the ambient order says that the post held by us will be recruited through NSSP. That is how we are agreed. We have not reached to that yet, Lordship. Initially, I also was under the impression that any appointment under the government, regular appointments are issued in the form of a so-and-so is temporarily appointed against the post of so-and-so. But then they are not on that.
Okay.
They are trying to take refuge on the decision of the cabinet at clause P, where it is mentioned that the regular recruitment shall be done through the NPSC.
Special NPSC drive.
Yes, but we are saying that we are submitting that no, this is pertaining to the other post because NSSP was not constituted on 23rd June 2020. NSSP has been constituted and notified in the Gazette only on 31st July 2020, 7 days after. Therefore, you cannot just derive and draw an inference that since you have mentioned about the regular recruitment will be done through NPSC, you are also governed that by this decision and the post held by you shall also be recruited through NSSP. That is what the government is coming. But my submission is, Lordship, the terms and conditions of advertisement cannot be altered, changed after commencement of the match. Rules were given, terms and conditions were shown in the advertisement. In response to the advertisement, we have applied for a
Mr.
post.
City,
Lordship.
let us once again go back to the advertisement. Let us once again go back to the advertisement.
Advertisement, yes.
Which is that page?
Page 22. 16 July 2020. Page 22, Annexure C.
Page, yes.
That's your Lordship, got it? In pursuance to the notification number so and so dated 2nd July 2020. 2nd July is the post creation order, Lordship, pursuant to the cabinet decision. Applications are invited for recruitment against newly created posts on regular basis under the Department of so and so. Why, Lordship? This cannot be treated as ordinary situation. Now that 3 years have already passed after the COVID-19 pandemic, people were so scared and so frightened. Even many employees have resigned from their posts. Why? For fear of death, for fear of life. So they have resigned from the post. And we were recruited in such a time that when nobody wants to even serve, we sacrifice our life. And then we applied for the post and we were selected. And now government is trying to say that, oh, it was a mistake on our part. With a gun, with a dao in your hand, you were chasing the person to kill, and then after chasing him, ultimately you kill. After killing the person, now you are saying that, oh, it was a mistake. It is like that. How the terms and conditions of advertisement can be changed after commencement of the match. That is as simple as that. That is my case. You have given the rules, I accepted and entered to the ground. And I'm playing. And then from the pocket, the referee has taken out something and no, this will be the rule. That was not the condition before I enter into the ground. And that is what the government is saying now.
Okay.
We were on page 27.
27. Yes.
So this was the administrative approval. And now the interesting part which my learned friend has tried to rely, page 29.
So here the administrative approval, you are aggrieved by the word temporary appointment.
Yes. And the imperial order is at page 36, where
Where's
the
your
post-
representation? Mr. Siti, where's your representation?
Representation is at page 40, annexure K.
Let us also read this. Let us also read this properly. This notification 5 July. 2020.
Yes. Because government is saying we have clarified and rectified by this notification. Page 29, type copy is more clear. May I read, Lords?
Yes, please. Yes, please.
Yes, on the recommendation of the cabinet, white letter number shows 25th June 2020, the governor of Nagaland is pleased to frame the following basic guidelines for recruitment and service conditions of the medical officers, nurses, technicians, and other paramedical staff as under. 1. All the newly created posts to be filled up by the Health and Family Welfare Department within a month's time with proper advertisement. While filling up the post, 2 weekdays each should be given to the marks obtained by the candidates in the qualifying degree of the university, medical college, and years of work experience. The interview panel to include independent experts from outside the state. Number two, this will be relevant for us. This appointment will be temporary, fixed, and regular recruitment shall be conducted through a special NPSC recruitment drive for all posts coming under the review of NPSC. Similar word is also mentioned here. So the clarification, initial concept of the cabinet is on 23rd June 2020. There it is mentioned as NPSC, and it has no mention about NSSP because NSSP was constituted only on 31st July 2020. Therefore, even if this notification is issued, the source, the basis of the decision, the policy was evolved when on 23rd June 2020 only. Therefore, we cannot be just dragged on so as to apply this clarification also, because the basis is the cabinet decision to fill up the post and to create the post. And the cabinet has clearly stated that with proper advertisement. So proper advertisement was issued. In response to the proper advertisement, we applied. And when the appointment order is issued, then it should be temporary. That is why it is unreasonable, arbitrary, and when there is arbitrary and unreasonable action on the part of
If
the,
you see serial number 2,
yes,
appointment will be temporary / fixed and regular recruitment.
shall be conducted through a special NPSC recruitment drive for all posts coming under the review of NPSC.
No,
So-
that's why,
Yes.
just let us see, okay, this. The appointment will be temporary fixed, stop there. And regular recruitment shall be conducted through a special NPSC recruitment drive for all posts coming under the purview of NPSC.
Yes.
So besides the NPSC post, besides the post which is coming under the purview of NPSC, the other post, the appointment will be temporary or fixed. That is what I understand.
And is mentioned.
Will be temporary fixed.
And
yes, so that has to be different. And regular appointment. So and is to be read in the context of regular appointment.
But this is derived from the initial cabinet decision.
Anyhow, submit.
Yes. Therefore, the para 2 is not applicable so far as the petitioners are concerned, because we are not coming within the purview of the NPSC. Now, the appointment orders, Lordship, page 32. Pursuant to the
Where's your representation?
our representation is page 40.
Okay. After the appointment order only, you submitted representation.
Yes.
After the, let's,
Yes.
where is that? Page 30. This is the appointment order. What is page 29?
Page 29 is the clarification of the government that it is not regular appointment, it should be temporary or fixed.
Page 29.
Yes, that is what government says. It is type copy. 5th July 2020. Initially, my learned friend was also trying to justify, basing on this, that we have already clarified that post will be temporary, not regular appointment. So in other words, the government is trying to justify that advertisement was a mistake on the part of the government. Therefore, by this order, we have rectified and clarified. That is what they are trying to show. But the cabinet decision remains intact, initial cabinet decision. And everything has been arising out of that only. Because government in their affidavit have clearly mentioned that it is an administrative oversight. In paragraph 5 of their affidavit, they have said.
Yes, come. Page 30. You are on
Page 32,
30?
Lordship.
32.
Yes, type copy. This is the appointment order.
Page 30 is.
32.
Page 30 is.
Page 30 is the appointment order, Lordship. And type copy is at page 32.
Okay.
That is more clear.
Okay. Page.
Raman is also saying that you have not challenged the advertisement, appointment order, where it is clearly mentioned that it is temporary appointment.
Page 32 is the appointment order, correct?
Yes. This is 3rd September 2020.
Yes, this is to do with this potential ECG, huh?
Yes. Is it necessary to read, Lordship?
Yes, of course.
Yes. May I read, Lordship?
Yes, please.
In pursuance to the Government of Nagaland Department, Health and Family Welfare, Nagaland, Kohima, approval letter number so-and-so dated 29 August 2020, the following persons are hereby temporarily appointed to the post of ECG technicians for a period of 1 year on contract basis as detailed indicated below in the pay matrix of so-and-so amount per month, level 5, plus all other allowances as are admissible under the rules from time to time in Nagaland with immediate effect. And the conditions are there. Those things may not be relevant. So the advertisement and the appointment runs contrary. Advertisement says for regular appointment, but when order was issued, it was issued on temporary, for a period of 1 year, that too on contract. And the government says that the advertisement was administrative oversight and the petitioners have not challenged the appointment order. We cannot challenge our appointment order, but at best we can submit a representation. Once we challenge the appointment order, then everything will go. So in the prayer portion, we have clearly mentioned that by filing this writ petition, we just want the government to modify our appointment order. It should not be temporary, it should be recurrent. And kindly come to paragraph 8 and 9, Lordship, where we have mentioned.
This is 3rd September 2020.
Yes.
So your term has expired. 1 year.
Yes.
And you are now?
Extended from time to time.
Extended from time.
Extension.
Okay.
Can we come to paragraph 8 and 9 of the writ petition? Because government is saying that, look, they have not complained, they have accepted those grounds. Government is trying to.
Your writ petition, Mr. City?
Yes, paragraph 8.
8 and 9.
Page 8, paragraph 8.
Paragraph 8.
I will read only 2 paragraphs.
Yes, wait. 8 and 9.
Yes.
8 and 9.
Yes.
Yes.
May I read, Lordship?
Yes, please.
That the petitioner speak to state that the advertisement was made for regular appointment on regular basis for a period for which the petitioners have participated in the selection process. However, when the appointment orders were issued, it was shown as contract basis. Therefore, the petitioner has approached the authorities about the discrepancies in the appointment order by questioning the terms of appointment. The petitioners were made to understand verbally by the authorities that their appointments are more or less regular appointment. This is what Lordship has pointed out. And formal regular appointment shall be passed in due course. In view of the unprecedented and extraordinary situation prevailing at the relevant time, and to tackle with one of the worst tragedies in the human history, and for the sake of humanity, the petitioners for the time being have opted to serve the people by accepting the said appointment. 9. That the petitioners speak to state that on further inquiry by the petitioners with regard to the terms of the appointment, of late it was discovered that by corrigendum number so and so dated 17 July 2022 has made some changes on the advertisement dated 16/7/2020 by correcting the regular appointment in case of OT technicians, ECG technicians, and other few posts to be read as temporary appointment. The said so-called corrigendum was never published in the print media, nor the petitioners were informed about the said corrigendum dated 17/7/2020. The petitioners have reason to believe that it was an afterthought on the part of the respondents and has been issued backdated in a secretive manner, as it has come to the knowledge of the petitioners only recently on further inquiry by the petitioners. So that is the background. And besides this,
This corrigendum is 17/7/2022. When was the advertisement?
Just one day after the advertisement.
No,
was
this
issued.
is 17/7/2022.
2020.
2022. I'm reading as 2022. Mr. Sethi, Learned Senior Counsel,
it should be, it's a typing error, Lordship.
it should be
I admit.
2020.
Yes,
It should be 2020.
You please make the correction.
Yes.
Yes.
Should be 2020, Lordship.
Yes. Yes, we'll give you enough opportunity.
And this corrigendum of 17 July 2020 is enclosed as annexure H.
Annexure H.
Yes.
Yes.
And type copy, Lordship will find at page 35.
35.
This was
Page-
never,
Page.
page
just-
35, 35.
Page 34 is the corrigendum, correct?
Yes, and type copy, better,
Yes, yes.
Lordship refer to the type copy, which is more
This
clear.
is corrigendum dated
17 July 2020. By this corrigendum, the
17.
regular appointment in the advertisement has been changed to temporary appointment. And as I was mentioning earlier, some of us have been serving in other states on regular basis. But after seeing the advertisement as regular appointment, we opted to apply here by resigning, because unless I resign, I cannot get the NOC also.
Where have you stated that in your petition?
That was not an issue, so I have not mentioned in my petition. And this corrigendum was never made public, nor intimated to us. And this was issued in a surreptitious manner. Therefore, by this action, the fundamental rights of the petitioners have also been violated. And another aspect, Lordship may recall that I'm an employee. I cannot dictate the terms and conditions of the service. It is the employer who can dictate the terms and conditions. I have no choice. And when the government, when the authorities arbitrarily dictate, then unreasonably dictate, it is the honorable court who can correct such arbitrary and unreasonable exercise of powers, Lordship. Should I switch on to the imperial order, Lordship?
Yes, yes, continue, continue.
This corrigendum of 17 July 2020 is a clarification issued by the government 1 day after the advertisement, but it was never made public nor informed to the petitioners as well. Therefore, the fundamental rights of the petitioners have been adversely affected. Now, page 36, Annexure I. This is the notification which is under challenge.
Impugned.
Yes.
This is the impugned notification.
Yes, impugned notification. This is 2nd November 2022. And we are challenging this on the ground that this notification is contrary to the advertisement dated 16/7/2020. Because first advertisement was for regular appointment, and by this we were
Okay, so
subjected.
this is the subsequent notification advertising the post.
Yes. May I read, Lordship?
Yes, please.
In the interest of public service and on the approval of the cabinet dated 26/5/2022, the Governor of Nagaland is pleased to notify the following post to be recruited through a special recruitment drive as indicated below. And the number of posts are shown. We are concerned with serial number 10. ECG technician, number of vacancies 10, class 3 non-gazetted, and the recruitment to be done through NSSP. And then clause paragraph 2. The special recruitment drive shall be conducted by the Nagaland Public Service Commission and the Nagaland Staff Selection Board. So we are agreed by this. The notification, the first advertisement was issued pursuant to a cabinet decision. And we have applied.
What is the status of this notification now? State.
State.
Okay.
So, in short, Lordship, the roles of the game has been changed after commencement of the match. Whether that is reasonable, whether that is arbitrary exercise of power, Lordship can examine that. And the same stringent condition is also shown here in paragraph 6, that who have resigned or left during the COVID-19 pandemic or refuse to accept the contractual engagement also shall not be eligible for any weightage for rendering COVID-19
Where is
services.
that condition?
Page 37, paragraph 6. That may not be that much important, Lordship. So far as we are concerned. And kindly come to Lordship, page 39, Annexure J, where the cabinet has relaxed with the recruitment rules for the special recruitment of health care workers, Lordship, on 25th May 2022. So, under any circumstances, the advertisement and the creation of post advertisement, everything has been, selection process has been done, taking into consideration
What is this cabinet? This cabinet agenda, relaxation of recruitment rules for special recruitment of health workers. Well, what is?
That is, they have not annexed. I have annexed in my reply.
No, this is
Annexure
a annexure J, no? Mr. City,
Lordship.
annexure J.
Yes.
Yes.
What is this?
This is the approval of the cabinet for relaxation of recruitment rules for special recruitment healthcare workers. Because during the pandemic, it was not possible to go through the regular process of recruitment. Therefore, in order to relax some conditions which is provided under the service rule, because during this period, not only the ACGs and the OTs, doctors, specialist people, professionals are required to be recruited, and then Ayush doctors who are class 1 gazetted officers. So many posts are there. Therefore, the cabinet has relaxed the recruitment rules, that it should not be like any other normal recruitment process.
But to be conducted by
NPSC.
NPSC and SSB.
Yes, because keeping in view of the pandemic, many healthcare workers, doctors, for example, there are many vacant posts lying, but unless it is regular, many doctors are not willing to join. Therefore, unless the role is relaxed, that is not going to be possible, and there is acute shortage of manpower in the health sector. For that purpose, the cabinet has taken a decision, even by creating new posts and conduct recruitment in a time-bound manner, so that the pandemic can be overcome, to fight with the pandemic. But now everything is normal as on today. So people have forgotten. People has forgotten everything. But what I'm submitting before your Lordship is taking into consideration of the background. During that period, cabinet decision is very clear. They have not just taken to favor someone, but in order to fight the COVID-19 pandemic, this special recruitment drive has been conducted and advertisement was issued on a regular basis. We applied, but when appointment order was issued, it was issued as temporary appointment. And then we were compelled to again face another recruitment under normal circumstances, either through NPC or NSSP. We are coming within the review of NSSP. But when the cabinet has taken the decision to recruit us, that time the NSSP was not even constituted. It was constituted only on 31st July 2020. Decision was taken by the cabinet on 23rd June 2020. Therefore, a subsequent decision, which was not mentioned in the initial decision, cannot be just connect and take an inference of that decision and impose on us. Our short submission is the advertisement was for a color appointment. We applied, but appointment orders were issued for temporary. So government is changing the rules of the game after commencement of the match.
Let us once again go back to the first advertisement.
Only our representation is left. Otherwise, all the documents I have shown to you.
After going through the first advertisement, let us go to your representation. Where is that?
Page 22, Lord.
Page 22. And when was this first cabinet decision?
23rd June. That is at Annexure A, page 18.
You are referring to page 19, nah?
Yes.
19A B.
Yes.
19AB.
Yes.
All the newly created posts should be filled up by the Health and Welfare, Family Welfare Department within a month's time with proper advertisement. While filling up the post, due weightage should be given to the marks obtained by the candidate in the qualifying degrees of university, medical college, and years of work experience. The interview panel should include independent experts from outside the state. B. The department should clearly indicate that all this appointment will be temporary and regular recruitment. The department shall clearly indicate that all these appointments will be temporary and regular recruitment shall be conducted through special NPSC recruitment drive.
So it talks about only NPSC. It doesn't say about NSSP. And there are many posts which are created by this decision. Therefore, it may be applicable to other posts, but so far as ECG and OTs are concerned, the cabinet decision has not mentioned about this post. It talks about the posts which are coming within the review of NPC. Because Lordship kindly see, page 18. Creation of 15 posts of junior specialist for the following community health centers. So, dear doctors.
Let us see the advertisement now. Memorandum of action, let us see the.
22.
Yes, in pursuance to notification so and so dated 2nd July 2020.
2nd July is the post creation order. In between.
Applications are invited for recruitment against newly created posts on regular basis under the Department of Health and Family Welfare through the Departmental Recruitment Board in the manner prescribed below.
Advertisement also doesn't say NSSP.
Are invited for recruitment against newly created posts on regular basis under the Department of Health and Family Welfare through Department Recruitment Board in the.
Because Lordship, the cabinet decision A says that it should be recruited by the Health and Family Welfare Department with proper advertisement. A. So that was done.
A.
Yes.
All newly should.
19, page
filled up
19.
By Health and Family Welfare Department within a month's time with proper advertisement.
Besides that, we cannot direct anything else more because cabinet has not decided that anything more.
Okay. Yes.
Only that much.
Your representation.
Besides that,
your representation.
I would like to, yes, representation. Page 41, 40. Prayer request to review the notification of 2nd November 2022. OT technicians and SCG so and so. Yeah, come to the body of the letter.
Yes, please.
Sir, with due respect, we would like to bring the following facts with regard to our appointment order during COVID-19 pandemic for your kind information and consideration, please. 1. That applications were invited for appointment to the above mentioned post wherein it was clearly mentioned that appointment will be made to the newly created post on regular basis under the department through the Departmental Recruitment Board. Whereas, upon receiving our appointment order, it was mentioned appointed for a period of 1 year on contract basis in the pay matrix of so and so per month level 5, which was a stark contrast of the advertisement published in the local dailies. 2. That, sir, you would be well aware that pay level 5 does not come under the purview of NPSC, and such appointments were made by the Department Recruitment Board legally. It is an understood fact that when the posts were created and our recruitment made, NSSP was not in existence. Therefore, to make a retrospective review of the advertisement and our subsequent appointment and placed it before the NSSP for fresh exams will mean gross injustice to us. 3. That, sir, it may also be mentioned that any corrigendum made to the advertisement on the condition of appointment was never noticed, published. That, sir, in the light of these facts highlighted above, we request your kind authority to restore our appointment as per the conditions mentioned in the advertisement therein and put to rest any decision taken at later dates. We have also rendered our services for humanity together with rest of the healthcare fraternity during the most trying times, and we feel we are right in questioning what is due to us. We would also like to request your kind authority to release our salary, which has not been paid for several months now, for which we are facing hardships. We shall be grateful for your kind consideration and necessary.
This is not a part of your grievance.
Yes. And all the petitioners have submitted. And the annexure L, page 43 is the extension order. And subsequent extension orders were given, and we are still in the service, Lordship. Now, that is the facts of the case. I would like to cite some rulings to substantiate my claim, Lordship.
Yes, please.
I'm just placing the. This is
Just
2000.
just 1 second.
I do not know whether it is arranged in the systematic order like I'm keeping.
Yes, which is the citation? you want?
2008 3 ACC 724.
Yes,
That is paragraph 11 and 12.
just wait.
On the point that
Para
11 and 12.
11 and 12. Let us wait. Just. Para 11 and 12.
We have heard learned counsel for the parties and perused the records. Mr. M.R. Kala, learned senior counsel appearing for appellants, has strenuously urged that during the pendency of the selection process, the eligibility criteria were changed and the date for submission of the applications in pursuance to the advertisement was extended, and Rule 266 of the Rules of 1966 came into being on 30/12/1996, whereby it was provided that higher secondary examination shall be the criteria for preparing the merit list. As such, as per the service rules, the selection should have been met on the basis of higher secondary examination marks and not on the basis of the secondary examination marks. We regret this cannot be accepted. Once the advertisement had been issued on the basis of the circular obtaining at that particular time, the effect would be that the selection process should continue on the basis of the criteria which were laid down, and it cannot be on the basis of the criteria which has been met subsequently. 12. As per the circular which was obtained at the time when the advertisement was issued, dated 24/7/1995, the criteria for selection to the post of teacher grade 3 was senior examination, secondary examination. 2. This was changed during the pendency of the advertisement. Subsequent amendment of the rules, which was prospective, cannot be made retrospective, so as to make the selection on the basis of the rules, which were subsequently amended. If this was to be done, then the only course open was to recall advertisement number 1 of 1996 and to issue fresh advertisement according to the rules which had come into force. Secondly, this was not done, and erroneously the authorities made the amended rules applicable and proceeded with the selection, which resulted into litigation, and ultimately Ramti Shyam Sharma succeeded in that litigation, and it was held that the selection should be made as per the secondary examination marks, the criteria which was prevalent at the time when the advertisement was issued. So that is one. And the second one is 2010.
One thing, Mr. CT,
Lord,
in this case, as soon as the posts were advertised, corrigendum was issued before the interview. No?
That document is already there on record. It was not published in the paper, nor the petitioners were intimated about these changes. And we have made categorical statement in our writ petition that this was issued in a secretive manner.
Mr.
Most probably, it was issued with a retrospective date.
Mr. N. Muzui, Publicity and Information Department was asked to give wide publicity.
Yes, Lordship.
Whether that has been done?
Lordship, as per the procedure, Lordship, we have to communicate to the publicity department, Lordship.
Oh.
Lordship, in fact, we have our website. It has been uploaded in our website also. They have downloaded the application from the website. It's uploaded immediately once any order or injunction is issued, Lordship. Because, Lordship, as my learned friend has been telling again and again, it was during the time of COVID. There was no question of meeting people.
So I'll hear you, but let me complete with the seniority.
This particular statement, which we have made, they have not denied. And Lordship is well aware, any statement which is not refuted, it is deemed to have been admitted. They have not said that this has been advertised.
Okay, next.
And my learned friend has submitted about the hardships during the COVID. When there was no difficulty for a department to issue the advertisement widely, open advertisement, what prevented them to issue in a similar manner the corrigendum as well? If at all they have issued just one day after the advertisement, that was made possible. It was advertised.
That was paper advertisement.
Yes, it was advertised in the paper. It was possible for them. But on the next day, it was made impossible for them. It was not possible. That is what they are trying to project. Now, the statement which we have made in the writ petition, they have not refuted also. It was not published. It was not intimated to the petitioners. They have not refuted this statement. Therefore, whatever we are submitting, whatever we are making the statement before this honorable court, it is correct. It is deemed to have been admitted.
Yes, continue.
Next citation, Lordship, 2010, 3 SSC. This is also in the similar line. Only one paragraph, that is paragraph 14.
Para 14.
Para 14 is short paragraph. May I read it?
Yes.
Similarly, in Ki Manjushri versus State of AP, this court held that selection criteria has to be adopted and declared at the time of commencement of the recruitment process. The rules of the game cannot be changed after the game is over. The competent authority, if the statutory rules do not restrain, is fully competent to prescribe the minimum qualifying marks for written examination as well as for interview. But such prescription must be done at the time of initiation of the selection process. Change of criteria of selection in the midst of the selection process is not permissible. This is what they have made it permissible. But Apex Court says that it is impossible, not possible. On the same, again, 2008, this is already referred to. Paragraph 27. 2008 3 5.2, paragraph 27.
Yes.
The last citation, Lordship, 2021, 10 ACC, page 116.
Yes.
This is on 2 points. Changing the terms of advertisement contrary to the terms and conditions of the advertisement. That is one. Secondly, the bargaining power is with the employer and the employee do not have choice to bargain. So on these 2 points, few paragraphs I would like to read, Lordship.
Kindly mention the paragraph.
Paragraph 12,
12,
17,
17,
21,
21,
25,
25,
26,
26,
27,
27,
29,
29,
36,
36,
42,
42,
43,
43,
48, and 49.
48,
Paragraphs are very short
and
paragraphs, Lordship.
49.
Although few paragraphs have been cited,
Okay.
but these are very short paragraphs, Lordship.
Starting from para 12. Starting from paragraph 12.
Yes,
Correct.
starting from paragraph 12.
Yes.
Paragraph 12, Lordship. It may be relevant to note that from the very inception of the advertisement until the final recommendation made by the Executive Council, undisputedly, a regular mode of recruitment was followed by the respondent university, making substantive appointment, but to the dismay of the appellants, as they are not in the equal bargaining position, were shocked to notice the arbitrary condition of the letter of appointment, restricting it to be on contract basis, limited for a period of 3 years, which either of the appellant was never been made aware of at any stage. And for the first time, such conditions were incorporated in the offer of appointment in contravention to the statutory scheme of the 1973 Act. This is exactly what has happened in our case also, Lordship. And para 17. After the university was converted into a central university under the 2009 Act, it came out with an advertisement dated 29/8/2011, inviting applications for appointment to the teaching post of various departments, including the Department of Pharmaceutical Sciences. That was the stage of grievance of the appellants, who were shocked to note that if such appointments are not now being made pursuant to an advertisement dated 29/8/2011, undisputedly, it will be at the burial of the present appellants, and they have to bear its brunt. Left with no choice, the teachers of the Department of Pharmaceutical Sciences approached the High Court by filing a writ petition under Article 226 of the Constitution, questioning the process of holding open selection pursuant to an advertisement dated 29/8/2011. At the same time, also questioned the arbitrary condition which were incorporated in the order of their appointment and prayed that they may be treated to be substantially appointed as a teacher in the Department of Pharmaceutical Sciences in the respondent university. The division bench of the High Court, after taking note of the submissions made, dismissed the writ petition under judgment and order of impugn dated 19/8/2013, which is the subject matter of the challenge at the instance of the appellants collectively in the present page of appeals. And paragraph 21. The main thrust of submission of the learned counsel of the appellants is that the process was initiated to hold regular selection pursuant to an advertisement notified by the respondent in the year 2004 and 2006, and after going through the rigorous of regular selection, arbitrary conditions were incorporated into your offer of appointment, left with no choice but to accept on the dotted lines being in the need of employment, and further submits that the scheme of the 1973 Act postulates of making regular selection on the recommendation made by the selection committee constituted in terms of the section 31 clause 1 read with section 31 clause 4 of the 1973 Act, and that being the procedure prescribed under the chapter 6 of the 1973 Act, incorporating arbitrary conditions at this stage into a letter of appointment was violative of Article 14 of the Constitution and Section 23 of the Contract Act 1872 and of the scheme of 1973 Act. And then paragraph 25. it's paragraph 25. Per contra, counter affidavit has been filed by the respondent, and while supporting the impugned judgment of the High Court, the learned counsel for the respondent submits the Department of Pharmaceutical Sciences was under the self-financing scheme referred to under Section 2, Clause 18 of the 1973 Act, which was introduced in the year 1996, and the state government sanctioned the teaching post of professors, readers, lecturers in the Department of Pharmacy under the self-finance scheme at a given point of time in April 1997, March 1998. Appointments were made on contractual basis, and later on, the government, by its order dated 4/2/2000, issued certain norms and guidelines for self-financing courses to be adopted by the university, pursuant to which the selection process was initiated by the university. 26. The learned counsel further submits that merely because the procedure prescribed under Part 6 has been followed, it does not give the undefeasible right to the appellant in seeking their appointment to be substantive in character, more so when the post itself was temporary, contractual, under the self-financing scheme, and its expenses are borne by the university itself, and by mere continuation of the university on the strength of the interim order passed by this court under self-finance scheme. No right could be conferred to seek regularization of their service. 27. The learned counsel further submits that after the respondent university was converted into a central university under the 2009 Act, appointments were to be made against the sanctioned post in the Department of Pharmaceutical Sciences by the Central University in terms of the procedure prescribed under the 2009 Act, and in furtherance thereof, the advertisement dated 29/8/2011 was notified by the respondents inviting applications for the teaching posts of various departments, including the Department of Pharmaceutical Sciences, and it was open for the applicants to participate in the selection process and to become a member of the service of the Central University. But when they failed to participate in the selection process and lost their battle before the division bench of the High Court, with their pay and allowances being borne by the university, no substantive right could be claimed by them merely because they are continuing in service under the order of the court for the last 15 to 17 years as spread forth, and it is still open for the appellants to participate in the selection process as and when held, provided they qualify the terms and conditions prescribed by the Central University under the 2009 Act. Para 29. The learned counsel submits that it is for the appellants to take their own decision, and once they have missed the bus failing to participate in the selection process, which was held by the respondent pursuant to an advertisement dated 29/8/2011, they are not entitled for any relief as being prayed for in the instant appeals. That was the contention like that in our case. And para 36. After the recommendations were finally approved by the Executive Council, appointments were made by the Vice Chancellor of the University, and at this stage, for the first time, arbitrary conditions were incorporated in the letter of the appointment, making appointment to be contractual for a period of 3 years in the first instance, which came to be extended at the later stage, like our case. 42. Para 42. The submissions of the learned counsel for the respondents that the appellant have accepted the terms and conditions contained in the letter of appointment deserves rejection for the reason that it is not open for a person appointed in a public employment to ordinarily choose the terms and conditions of which he is required to serve. It goes without saying that employer is always in a dominating position, and it is open to the employer to dictate the terms of employment. The employee who is at the receiving end can hardly complain of the arbitrariness in terms of the in the terms and conditions of the employment, this court can take judicial notice of the fact that if an employee takes initiation in questioning the terms and conditions of employment that would cause his or her job itself. 43. The bargaining power is vested with the employer itself. An employee is left with no option but to accept the conditions dictated by the authority. If that being the reason, it is open for the employee to challenge the conditions if it is not being in conformity with the statutory requirement under the law, and he is not stopped from questioning at a stage where he finds himself aggrieved. So exactly we have done as is mentioned in this paragraph. 48. Adverting to the facts of the case, undisputedly, the appellants were appointed pursuant to an advertisement dated 4/2/2004 and 19/5/2006, held for regular selection, and after going through the proper selection of being provided under Chapter 6 of the 1973 Act, and on the recommendation have been made by the Statutory Selection Committee constituted under Section 31, Clause 1 and 4 of the Act, and approved by the Executive Council, which is statutory authority. Appointments were made in the year 2004 and 2007 respectively. 49. This is the opinion arrived by the court. In our considered view, once the appellants have gone through the process of selection provided under the scheme of the 1973 Act, regardless of the fact whether the post is temporary or permanent in nature, at least their appointment is substantive in character and could be made permanent as and when the post is permanently sanctioned by the competent authority. In our case, the post has been created under pursuant to a cabinet decision. It is permanent. Advertisement has been issued for regular appointment against which we applied, and then we faced an interview and got selected. And Lordship, very importantly, the COVID-19 pandemic period should not be easily overlooked, Lordship, because we have made a lot of sacrifices during this period. And taking into consideration of all this background, the recruitment, everything has been made. And in the late of the day, when everything is normalized, they cannot take a U-turn and come with a plea that on the ground of mistakes or administrative overlooking all this. So I conclude my submissions with that, Lordship. I highly appreciate.
We'll continue tomorrow. Okay.
Lordship, pardon me, tomorrow I have some re-engagement. I may not be able to attend, but my junior will be there.
It's all right.
If there is any clarification required by your Lordship.
Because I think it's still time we should go a little
This
slow.
season is very difficult to conduct cases, Lordship.
Correct.
Again, tomorrow, and then after one day, again on 26, of course, that is a holiday. Down to Timapur, moving like a shuttlecock.
I don't know how you are feeling, but for me, it's horribly cold. I cannot conduct cases. Just
Even for us, Kohima people also, we are
it's
facing
that biting
difficulties.
cold. Huh?
Yes. It's freezing cold, I should say.
We'll continue tomorrow.
Lordship.
You also try to get that notification which was issued to the publicity department for white publication.
It's there in the letter itself, original copy to DTPR for publicity.
No, that is there, but whether it was published or not,
Lordship.
that is the issue, whether it was published or not.
Yes. I can show Lordship, besides the publicity, the uploading of the original in the, yes.
Mr. Senior Counsel's submission, when you can actually advertise, when you can advertise in black and white. What prevented you? Immediately the next day. We'll continue.
Lordship, that clarification will give Lordship, yes.
But try to get something in black and white
Yes,
about the.
in sequence, Lordship, because my learner's friend has been jumping from one to another, but the sequence that has been maintained by the department, Lordship, how it has been issued, Because prior to issue of the advertisement, there's already a direction by the government that temporary employment will be there, not regular. So the administrative oversight, Lordship, we are not denying it. It was admitted by us. There was administrative oversight, Lordship, but immediately on coming to know, once the advertisement was issued, direction came from the government that there cannot be a regular recruitment because there's already a cabinet decision and a notification also while post-creation was done. Lordship, I'll come to the sequence because my learned friend is jumping from point to another point. Rather confusing, everyone here.
But I was referring only to the relevant documents which will be necessary to be decided by the
Yes,
Honorable.
and in fact, I'm relying on one cabinet decision also, how it was.
But the basis will not be changed. Basis is on the 23rd June 2020 decision of the cabinet.
Heard.
We cannot apply pick and choose.
Mr. C.T. Jamir, Learned Senior Counsel, assisted by I.M. Chin. If I'm not
Correctly.
mistaken now.
Absolutely, there is no mistake.
Counsel for the petitioner. And Mr. N. Nazui, the learned counsel for the respondents. The matter remains parted, listed. Tomorrow, what is the date?
25th.
Listed again on 24/1/2024 as the first hearing.
Lordship. Okay. Lordship, along with the other items. There are two items.
34 and 35.
34 and 35, yes. Yes.
Lordship.